In this video, we will cover the topic of Annual General Meeting AGM. Since we already have gone through that annual general meetings are very much required for the happening of the transactions in the company, right from appointment of director to taking important decisions. Section 96 of Companies Act provide for annual general meeting. It says every company is required to call at least one meeting of its shareholders each year. So in this annual general meeting, all of the shareholders will be there, and that decision will be taken as per the required resolution and quorum. So first AGM has to be done within 9 months from end of first financial year. Now the gap between two AGM shall not be more than 15 months. These are the statutory requirement as per section 96. If company fails to hold AGM, then any member can apply to the tribunal, and tribunal would order the meeting under section 97. So AGM can be conducted by company, and it has to be conducted by company, but if company fails, then it can be conducted through tribunal. Now failure to call meeting generally or in pursuance of tribunal order is punishable under section 99. So if as per section 97 tribunal has ordered to conduct AGM and company failed to follow the order, then it is punishable under section 99 with fine which may extend to 1 lakh, and if it is a continuing default, then further fine for each defaulting day which may extend to 5,000 rupees per day. In Shri Meenakshi Mills Company Limited versus Registrar of Joint Stock Companies, company adjourned the AGM to be held in December 1934 to December 1935. So there was AGM which was held to be conducted in December 1934, but it was adjourned to March 1935, and it was conducted in March 1935. After this, the next meeting happened in February 1936. The prosecution was not holding a meeting in 1935. So this was the matter. The matter was that there was no meeting held in 1935 because the meeting of 1934 December was adjourned to 1935, and then after this next meeting in 1936. So technically when a meeting has happened in 1935, no meeting. So company was convicted, and court said that there should be as many meetings as total number of years. Now bona fide members are not convicted. For example, if members who are not at fault, they will not be convicted for non-conduct of AGM because it was not their fault due to which AGM did not happen. So only members who are liable or who has committed the fault, only they will be liable. Since ultimate control of company should be in the hands of shareholders, it is significant that shareholders should come together once a year. Now appointment, removal, reappointment of director, auditor, declaration of dividend, and so on are the important tasks to be done at AGM. Then there is EGM, that is Extraordinary General Meeting. Schedule 1 Table F and Section 100 talks about this. General meetings other than AGM are EGM, that is Extraordinary General Meeting. It is called by board at their own suo motu or on the basis of requisition. Requisition, who will make the requisition? If company is having share capital, then requisition is to be made by shareholder having 1/10 paid up capital with voting right, and if no share capital is there with the company, then requisition to be signed by members having 1/10 of total voting. From date of such requisition, within 21 days, director shall move to call the meeting, meaning thereby they should start the process. And within 45 days of date of requisition, meeting shall actually be conducted. Now these are the few important points as to valid meeting. Meeting shall be called by appropriate authority, that is board, and in exception tribunal. In Harbin versus Philip 1883, what happened? Director called the meeting but restrained few directors from attending the meeting. However, the quorum was obtained in absence of these directors, which were restricted, but court held that meeting is unlawful. Now, technically, quorum is there. If quorum is there, you can go with the meeting. But they were restrained. They were restrained intentionally, and such illegal and wrong act will not amount to a lawful meeting. So, meeting was held to be unlawful. Proper notice has to be given. Section 101. Proper notice has to be given. So, this notice should be clear. A deliberate omission may invalidate the meeting even if such omission is in context of one member. Even if one member has not been sent the notice and it is a deliberate omission, then it may invalidate the meeting. Accidental omission will not be fatal. Then notice must be given 21 days before the date of meeting. In NVR Nagappa Chetiyar versus Madras Race Club, what happened? Date of the meeting was 7th November and notice was posted on 16th October. So notice was found to be short by 1 day, as while computing 21 days, date of posting of the notice and date of meeting shall be excluded. Now, relevant information. Notice to meeting shall state business to be transacted, for what purpose the meeting is to be conducted. Now, business could be divided into general business and special business. General business means accounts, director's report, dividend, appointment of director and auditor and their remuneration, things like that fall under general business. And special business means any other business plus all the business which will be dealt as EGM, extraordinary general meeting, falls under special business. Now, statement of disclosure, section 102. What this statement? This requires full and frank disclosure of fact on which shareholder are to vote, meaning thereby you need to tell the shareholder exactly what is the purpose of the meeting, what do you want, what is the decision, what could be the possible benefit of that decision, what could be the disadvantages which may be there. So pros and cons and the likelihood of positive attributes and negative, everything has to be shared with the shareholder, because the shareholder, they have put their stake, they have put the money in the company and their notion should be secured, and they have committed and they have connected themselves with the company and invested in the company, so they are very much interested. Now, interest of director and key managerial personnel. If there is any interest of director and key managerial person, that has to be mentioned specifically. However, it is to be noted that if these things are mala fide, then it will not constitute a valid meeting and will implicate the director and key managerial personnel, as the case may be. Nature of concern. Is it a financial one or otherwise? It has to be mentioned in the statement of disclosure and any relevant information there. If statement of disclosure is not complied with, then there is liability. 102 clause 4 and 5 talks about the liability. 102 clause 4 says that the concerned person has to compensate the company if due to non-compliance he received directly, indirectly any. So the person has not made these disclosures, and because he did not make the disclosure, he gets some benefit directly or indirectly, then he has to compensate that. And clause 5 says concerned person is liable to pay fine, which may extend to 50,000 rupees or 5 times the benefit secured, whichever is more. Chairman is necessary. 104. Section 104 makes the presence of chairman necessary, and who could be chairman and how things will happen will be regulated by Article of Association, that is AOA. Usually chairman can adjourn the meeting, he has power to adjourn the meeting, he can postpone the meeting, he can cast a vote in case of a tie, and he may be appointed by court as well. Voting. Now, business is done by resolution, resolution is passed by vote. So section 106 allows member to cast vote irrespective for time for which shares have been held by them. only ground prohibiting him is non-payment of call. So it hardly matters whether he has been having the share from 1 year or from 5 months. If he has share, he has a right to vote. And the only ground for prohibition is non-payment of calls. Call means call for share, which we have already done. Now voting may be done by showing hands. You will raise your hand and then it will be counted 107. Voting by electronic means 108, and polls 109. If dissatisfaction is there about result by showing of hands, then you can go for polls, and then proxy voting 105. Now resolution. To pass a decision, resolution has to be taken. Resolution as per section 114. So resolution could be ordinary resolution and special resolution. Ordinary resolution means simple majority of shareholder present and voting. Example, 30 members is there, 20 say yes, 10 says no, so majority is there. Then special resolution means it requires 3/4 majority. Example, 40 members are there, then it would be 30 members. If 30 members say yes, then it will be happening. Now by virtue of article of association, for purpose of some specific meetings, if company wants to have a typical voting or typical segment of number, then it may be done, but it will be seen the purpose and whether it is contradicting any statutory requirement or not. If it is not contradicting any statutory requirement and it is bona fide one, then it may be accepted. Now quorum 104, section 104 talks about quorum. Quorum means minimum number of members required for a meeting. Unless these minimum members are there, meeting cannot take place. So if quorum is not there, in case of general meeting, it will be adjourned for next week, same date and same place. And if quorum is also not there on the adjourned date, this next week, then member present shall be the quorum. The total number of members who are there, they will form the quorum. Now if it is extraordinary meeting, then it will be cancelled. Now if article of association provides for the quorum, it will be followed. Otherwise quorum will be, for private company, minimum 2 members who are personally present in the meeting. In case of public company, if members are not more than 1000, then 5 members will form the quorum. Personally present, they will be there present personally. If members in public company are more than 1000 up to 5000, okay, then it will be, quorum will be of 15 members, and if it exceeds 5000, then quorum will be of 30 members.